Hi, good evening. It's a very interesting judgment. Income Tax Act, transfer pricing issue, legal services. So, Delhi High Court judgment. Citation is Commissioner of Income Tax versus Clifford Chance Private Limited, PTE Limited, Singapore company. So, DTAA relates to Singapore. Issue is virtual service permanent establishment. Whether constitutes a service permanent establishment within India or not. That is the issue. Facts simply put, non-resident company engaged in legal services. Assessment year 2021, 21-22. Draft assessment order passed by the AO proposing to make additions. Naturally, if transfer pricing issues, nothing is less than 10 crores. 22 years, so amount is immaterial. Assessee approached DRP. DRP dismissed the objections and confirmed the order of AO. So AO passed the final order. Then this final order was challenged before the tribunal. Article 5(6) of the DTAA between India and Singapore contemplates an enterprise shall be deemed to have a permanent establishment in the contracting state through its employees or other personnel only if the activities within the contracting state, that is important, through the employees or other personnel, that is also important, continue for a period aggregating to 90 days in any fiscal year. So two things, one is within the contracting state, another is through the employees or its personnel or others. The contention of the department was, since the activities were also virtually performed by the assessee from outside India, a virtual service permanent establishment has been established. AO observed that duration of physical presence of the employees in India is immaterial. This view of the AO is approved by the DRP. So assessee filed an appeal before the tribunal. Tribunal said actual performance of services in India by employees physically present in the country is necessary. So the tribunal's view is virtual service is not applicable. Physically present in the country or not, that is important. Since the assessee has only rendered service to its clients only less than 90 days, that is by being physically present in India, it does not meet that 90 days threshold criteria to constitute a service permanent establishment in India. Then the commissioner appealed to the Delhi High Court. Delhi High Court said the words within a contracting state and through employees or other personnel contemplates rendition of services in India by the employees of non-resident enterprise while mandating a fixed nexus, that is physical footprint within India. The term within has a certain territorial connotation, and in the absence of personnel physically performing services in India, there can be no furnishing of services within India. A plain reading of the whole provision reveals that if such services are rendered by employees present within the country, then only it would constitute a service permanent establishment. That is, simply put, Delhi High Court agreed with the tribunal. No, the employees are not present for 90 days within India, hence it is not a permanent establishment within India. Delhi High Court said the concept of a virtual service permanent establishment does not find mention anywhere in the DTA between Singapore and India. The court reasoned that the law, insofar as the present controversy is concerned, is clear and unambiguous. DTAA, which has been carefully drafted and executed after numerous rounds of bilateral deliberations and negotiations at the highest level, it must necessarily be interpreted strictly. If something is conspicuous by its absence, The presumption is that it has deliberately been done so. It is not for the court to read in concepts which are not expressly provided for by the treaty. The guiding principle here is the language which is not explicitly included in treaty provisions cannot be artificially be read into such provisions by way of a judicial fiction. This is very important. So I read it again. The guiding principle here is language which is not explicitly included in treaty provisions cannot be artificially be read into such provisions by way of judicial fiction. Kindly note this. Article 56 of DTAA only contemplates rendering of service by employees present within the contracting state. If that be so, it is not for the court to analyze the status or merits of a virtual services permanent establishment which does not find mention either in the DTAA or in the Domestic Act. As such, the contention of the revenue that a virtual service permanent establishment of the assessee has been established, this contention was rejected by the High Court. The AO in its order gave examples of some countries like Saudi Arabia, Israel, and Kuwait to show that in the present digital economy, even if services are performed entirely offshore, it would constitute a service permanent establishment. This was also rejected by the High Court, stating that the submission is at variance with the treaty language of DTAA, which expressly provides that a permanent establishment of an enterprise shall be deemed to have been established in the contracting state if it furnishes services within the contracting state through the employees or other persona. That is, again, the court is saying that it must be proved the physical presence was there for 90 days within India. Virtual thing is rejected. The court said this concept has not been administratively recognized by India, and in the absence of any changes made to the treaty provisions of the DTAA, such developments do not alter the interpretative constraints imposed by the wordings of the DTAA, which is applicable on all fours in the instant case. In fact, until Article 56 of DTAA is renegotiated or supplemented, the existing treaty framework does not extend to virtual or digital services provided from abroad. That is the view of the court, and the High Court has dismissed the appeal filed by the Commissioner of Income Tax. My comments. The court says the wording of DTAA is within a contracting state through employees or other persona. This contemplates physical presence of employees within India. That is the view of the court. I think the DTAA clearly says service must be within India rather than the presence or absence of the employees. The question is whether you have provided services within India or not. That is the question to be seen. It never talks about physical presence or absence of the employees. Court itself says, High Court itself says, guiding principle here is that language which is not explicitly included in treaty provisions cannot be artificially read into such provisions. That is what the court says. If that is so, can the court add words to the treaty by stating within the contracting state through the physical presence of the employees or other persona? That has not been stated by DTAA. Within the contracting state, that is through the physical presence, it is not there. The DTAA says within the services provided within the contracting state through employees or other persona. That's it. So, can the court add through the physical presence of the employees or other persona? That is the question. So, in my view, with greatest respect to the court, I differ, because services are within India. Whether you performed it, it is also performed. There is no dispute. They sit anywhere, Singapore or America or any place. These services were performed within India. These people were performing the services from Singapore within India through their employees. That has not been disputed. So, anyway, definitely court's view will prevail. My view is should be rejected. I myself reject my view because the view of the uh, Delhi High Court will hold the field till it is reversed by Supreme Court. Thank you very much. Have a great evening. Bye.